Welcome to this second panel on avatars and personal identity in the metaverse. My name is Julián López. I am Associate Professor at the University of Alicante, and I will be chairing this panel. As we will follow the same format as the first panel, it does not need any explanation. In this panel, we will explore the multifaceted dimensions of avatars in the metaverse, from the role as self-representation and social dynamics to the legal, psychological, and ethical implications that they entail. And to illuminate the transformative potential of avatars and contribute to this discussion, we will have 4 brief presentations, again maximum 10 minutes, followed by the comments of the discussants that will start what I hope is going to be a fruitful discussion. First, I will start, or I will follow the order of the program. First, we have Vera Lúcia, RAPOSO, Assistant Professor and Deputy Director for Value Creation and Internationalization at Nova School of Law, Lisbon. And she will present her paper on Metaverse Legal Matrix, Avatar Realities and Legalities. Vera Lúcia, you have the floor.
Muchas gracias. ¿Me puedes poner slides? Yeah. I'm going to speak in English. This was just to... Well, muchas gracias. Yeah. Yes. So, I don't know if you remember Matrix and amazing Keanu Reeves. Unfortunately, this is not the topic of my talk. I'm just trying to call your attention, especially the ladies. Yes, I'm going to talk about something much more mundane, basically the legal status of avatars. And I'm going to refer it either first to the existing law nowadays and afterwards to a kind of perspective law, and also trying to find possible solutions for some of the main issues that are being raised by avatars in light of the identified legal status. So starting with the law that we have nowadays, and as you know, it's very, scarce because we don't have any particular law specifically addressing avatars. So first question, do avatars have a legal standing of their own? I heard some scholars saying that yes, that they should be granted legal personality. Quite frankly, this is a little bit far-fetched for me. Of course, we can discuss what are the criteria to recognize legal personality to an entity, but right now I don't see if there are sound legal reasons to do it in the case of avatars. Because the avatar is kind of a reflex in the mirror of myself, the creator of the avatar. It's like a puppet. Of course, we in the legal world, we are not very creative because you have either the person, either the object, but we'll say in latent duress, and there is nothing in between, even though some advocate, including myself, the status of the tertium genus, let's say for the unborn and animals, but even the tertium genus, I think it's a little bit too much for avatars. So in my view, right now, there are objects, digital objects. And this, of course, will dictate some of the solutions for the problems that I have here. So for instance, sometimes imagine that you encounter an avatar in the metaverse and you are not very sure if there is a person controlling the avatar or if it is a machine, because you might have an avatar that is controlled by AI. So you have like a kind of a chatbot embedded in the avatar. And how do we know if it is a person there? For that, you need to look into the AI Act, our future AI regulation. Article 50 addresses AI systems that interact with humans. And what the norm states is that the providers of these AI systems must inform very clearly the human interacting with the chatbot that this is a machine, this is not a person. So you need to have some kind of, watermark, whatever, to indicate this is AI, this is not a real human. In some other cases, what happens is that the avatar not only sounds like a person, it looks like an actual person, someone that we know, eventually someone famous. Now, let me do a test. Do you know who is this one? You are all too young probably, but if you have my age, you will know. So she is Karen Kirby. She belonged to a group that was quite famous fairly today, Doolittle. And look, she was famous because she had like the red hair, she was a singer, of course, she was famous for that. But she had like the red hair, very flamboyant clothes, the way she moves, she got the move. And she was specifically famous for her, let's say, signature sound, which is ooh la 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 la. So that's how she sounds. And now, look at this one. I know, it doesn't really look like her. But if you notice, she was this avatar, like the clothes, and she also dances in the game. This was a character that was an avatar launched in a game from Sega. And her name, ooh la la. So, you see the connection, right? Well, Karen Kirby also saw the connection, and she filed a lawsuit against Sega, saying, guys, this is a violation of my right of publicity. This right never gained attraction in the EU, but it's huge in the US. So basically, it's a kind of property right, a little bit like an IP right, that gives me the power, or the right if you want, to gain all profit that is created by my looks, my image, my features, everything, and Karen Kirby was invoking the right of publicity. Well, the court said, not really, she's not really like you, they are not copying your image or something like that. We may agree to disagree, this is a little bit subjective. What I can tell you is that we have in the States some other lawsuits of this kind, usually involving the gaming industry and usually invoking sport figures, and sometimes the court does uphold the right of publicity. Now, if we assume that the avatar is indeed an object, who owns the object? Or in particular, who has IP rights over that digital object and can make profit with it? And for that, let me tell you the story of Leroy Jenkins. I don't know if you are in the game scene, maybe you know him. This is Leroy Jenkins. He was an avatar created in the World of Warcraft, and then it became quite famous. It appeared in other games, even in movies. Now, funny fact, it was not created by Blizzard Entertainment, which is the company that owns the World of Warcraft. It was created by this guy. So Ben Schultz is a gamer. He was playing the game, and he created that particular avatar. Because back in the days, when you were playing a game, the platform gave you the avatar already finished, so you just have to play with it, so to say. But now, a part of the game is ensembling your avatar. So you create a specific face, a figure, the clothes, the way it moves, even kind of a personality. So imagine that your avatar becomes famous, like Leroy Jenkins. Are you going to make money with it? Huge discussion. Some say the IP rights belong to the company, some say they belong to the players. Well, I'm not an IP expert, but I will go for a joint IP rights divided between the two. Some cases majorized in courts. In this particular one, it never went to court. I will say there was an extrajudicial agreement between the two parties, and they all benefited with it, of course. But what I will recommend is to have the case or the conflict settled beforehand in the terms and conditions of the platform. Now, last question, because I'm running out of time here. What if someone destroys my avatar, assuming that it is indeed an object, like a digital object? What if someone destroys it? Well, there was an incident back in 2008 with the Japanese woman. Everything interesting happens in Japan, I might tell you this already. So the woman had an avatar in a virtual world, and their avatar married with another avatar that belonged to a man. And they lived happily, very happy, until the moment when she was faced with a request for divorce in the virtual world. And she got so terribly upset that she took advantage from the fact that while they were married, she had access to the credentials of her fake husband, digital husband. And so she used those credentials to get into the Metaverse platform as being him and completely destroying the avatar. Now, what is funny is that UCC, the newspaper talks about murder. And, well, funny enough, some people were discussing if this was an avataricide, like a kind of homicide of an avatar, which is, of course, completely crazy using this particular crime in criminal law. I do believe that we might have some crime here, eventually illegal access to data, illegal destruction of data, something of this kind. And what we might have is compensation for moral damage, because some people get very deeply attached to their avatars and might feel this as a kind of moral damage. All of this is only valid assuming that avatars are objects, digital objects. It might change, however. Let me see if this also changed the slide. No. Yes. In the near future. Because, look, imagine that you have an avatar that is controlled by AI, but not the kind of AI that we have nowadays that we used to call narrow AI, but the so-called strong AI. Of course, we don't know very well how strong AI will like, but experts say that will be something completely independent from its creator, with kind of a will of its own. And if that is the case, look, if, we don't know, but if that is the case, I think that probably we will have no other option than granting legal personality to this form of AI. Not the same one that legal persons have, of course, not the same one that we have as natural persons, but maybe something alike. And this will also have to be recognized to these kind of AI-based avatars in this prospective future. So if that is the case, we might have like an avatar person or a meta person, eventually, as I told you, with rights and obligations, not the same ones that we have, but more limited in their scope, different rights and obligations. And this will open the door to all new questions. So for instance, in this future, I assume that these avatars will be accountable for civil and criminal liability. Again, more questions. So in terms of civil liability, how will they pay a compensation? Probably we'll have to go for the socialization of risk and create a kind of a fund to pay for compensation. Or if these avatars are indeed so independent, it might be that they have assets of their own and they can pay the compensation. Bank accounts in the name of an avatar, I don't know. Criminal liability is even more complicated because we will have to adjust the penalties we have nowadays to avatars. So what we have here, like a detention in a digital jail of the avatar, the suspension of legal personality or legal capacity, even a kind of death penalty of the avatar in the digital electronic chair, you might destroy the person whatsoever, and I don't even know. My brain cannot imagine all the possible consequences. And of course, if this meta person will have obligations and duties, eventually it might also have rights. And we might have to create a charter of rights for avatars, and we have to adjust the rights, the fundamental rights that we know nowadays, to adjust to this avatar figure. And now imagine this scenario, and I know, I'm just going out of the road, but let me be wild. Imagine that you have an avatar in a platform, and the avatar, this independent avatar with legal personality, says, you know what, I'm sick and tired, I want to be free, I'm a slave here, I want to have control of my own life, and go into the metaverse. Everything is possible. So, I know this is quite far-fetched. My point is, we are on the brink of a brave new future. It's a brave new world, especially for you young researchers. People tend to say that we lawyers, we are not funny, we don't have sense of humor. But believe me, I do believe we are on the rope for being very funny people, and because it will be very funny to be a lawyer in those days. Thank you so much, me and my avatar, thank you. Thank you.
Thank you very much, Vera, for not only for sticking to the time, but also for this amazing presentation. I am sure that it will raise many questions. Now we will move to the second speaker, Lorena María ARISMENDY, MENGUAL. She's private law professor at CUNEF University in Madrid, but also visiting academic at Oxford University and research associate at Keble College. She will present her paper on holding avatars accountable, the issue of damages in the metaverse. And I think that connects with the previous presentation.
It really, can you hear me? Yeah, it really does. So thank you for the presentation. I feel really honored to be here, of course, and just share some lines of my current research. For the sake of brevity, I have narrowed the scope of my research to the issues arising from avatar misconduct, mainly in online virtual worlds, rather than the metaverse as this whole bigger technological landscape when it is harmful. The central question is whether actions carried out using avatars in virtual environments can be translated into an existing civil liability framework, leading to an enforceable legal consequence, which of course would be compensation. The main reason to focus my research on online virtual worlds rather than the metaverse is because of the current landscape of the metaverse, which we have to be realistic. Each company entering the metaverse business will likely design their own, I really dislike the word metaverses, like lowercase and plural, but will design their own virtual world, and access will be restricted, which is commonly referred to as walled gardens, as you can see in the pictures. Like I said, I try to be realistic, notwithstanding the much expected evolution of these metaverse dynamics. So, the metaverse is often regarded as a wildly different world, completely detached from our current reality, which is why the applicability of our real-world laws in the metaverse should be addressed. We have some strong evidence, so this is the real world, we have some strong evidence that infringements taking place in the metaverse warrant real claims in the real world. Some cases are already a classic among metaverse scholars, and these highlight real-life applicability of our law in the metaverse. For example, I won't refer to all of them. Feel free to ask, and I'll come back to this. For example, we have Bragg versus Linden, in which they questioned the enforceability of arbitration clause in the terms of services of Second Life. We have the iconic Meta Birkins case, recently settled in favor of Hermes because of a trademark infringement. However, today I mainly wanted to underscore the recent Ada case, which is ongoing in China. This is not really technically metaverse related, but rather avatar related, because for the first time, as far as I'm concerned, a court of law judged the issue of whether a digital avatar is directly entitled to a copyright or related right protection. So, as I said, in this focus, I want to focus specifically on avatars and their behavior on online virtual worlds. For what I consider it would be useful to show you what an avatar behavior-related infringement looks like today, or 2 years ago, if you will. So, a trigger warning, this might be a sensitive topic. I will address an instance of alleged sexual violence, so viewers' discretion is advised. Can you click here? Thank you.
Free stuff. No worries. Hey, free stuff. Yeah, free stuff.
This is an already well-known case, happened 2 years ago, and what you just saw happened 2 hours after a researcher entered a Meta Horizon world. This researcher was using a female-looking avatar, and she was led into a private party or a private room where she was allegedly, and here it is, raped by a user who kept telling her to turn around so he could do it from behind while users outside the window could see. I'm just reading the report. And what I wanted to highlight is that this sexual act, the last lines, was non-consensual, and the researcher described the experience as disorienting and confusing. One has to consider that this is a first-person immersive experience. When you see the camera going to the right, it's because the user is moving her head to the right. So what she described, the researcher describes with this experience, is what is often known among scholars as a digital reality. And this is what I believe makes metaverse incidents relevant to the law. Because what you just saw might not constitute, I'm not an expert in criminal law, I don't intend to be, but what you just saw might not be actual sexual violence in terms of our existing laws. But the feeling of disorientation and confusion that the researcher felt are very real, as much as other socially or legally acceptable types of distress that may give rise to a real-world claim in a real-world court for compensation. So this is, I'm so sorry. Yep, thank you. So, regarding avatars, of course, we often refer to them as digital twins. Customization options are often extensive, although they mostly look rather cartoonish. But I wanted to focus on the fact that they are immersive elements. In the metaverse, you are your avatar. And as such, the avatars are mere conduits for user behavior. This means that they are essentially controllable. We have heard something about maybe avatars being AI equipped. This gives rise to more complex questions, but they are essentially controllable either by a legal, natural person or otherwise, possibly an AI agent. So, the relevance of avatars have led to claim for a proper regulation for them, and this discussion has been going on for almost a decade now. Although it hasn't been successful yet, avatars do not have legal personality as of today. This particular discussion will set a difference between talking about misconduct by an avatar, meaning they have been granted legal personhood or misconduct through an avatar. I discussed this in a recently published paper, and I tend to agree more with this latter approach because it is far more likely today and would entail, as mentioned here just before me, to consider them as things or as the subject matter to a service contract rather than as a person, giving us a more feasible approach for a legal framework. Moreover, it lets us pinpoint a liable agent, which is none other than the user. As you can see, the user controls the avatar, so avatar wrongful behavior is actually user wrongful behavior. There are other types of issues regarding avatars. They are very much fun to talk about. I would like to come back to any of this should a question arise on this regard. But let's talk about the legal framework for avatar use, starting for us to how to access your avatars today. There are different layers. As you can see, we have the metaverse, this big technological landscape. And to enter this online virtual worlds in which you could use your avatars, you have to go through this barrier, what we refer to as a walled garden. You can see it here. That would be the end user's license agreement or the terms of services of a given online virtual world. These are not mere formalities. These are detailed regulation of detailed regulation for user conduct and grants extensive power to platforms or the controller of a virtual world to penalize the user for infringements. So what should the legal consequence for an avatar misconduct causing harm to other be? Of course, compensation, but how to get there? One could consider at some point a secondary liability approach based on the DSA, the Digital Services Act. However, the Digital Services Act does not directly establish or harmonize or create new European Union-wide framework for civil liability related to online platforms and services for users' misconduct. So injured parties will need to rely on national tort law and liability provisions when seeking civil compensation. This means to assess the framework of non-contractual civil claims for damages caused through an avatar where such claims are brought under a fault-based liability regime, such as the Spanish regime, which I take as a reference here, where the general rule is that of liability based on fault. While examining national rules, I have focused my research on user liability, of course, for avatar misconduct, considering that the user is in fact the controller of the avatar in the online virtual world. I argue that existing laws should apply to avatar misconduct without the need for further adaptation. Current regulations are therefore sufficient and should be enforced in cases of wrongful behavior conducted via avatars. Some aspects arise assessing this question as a matter of a liability regime. We could consider, for instance, strict liability. However, the rules provided in most civil codes do not seem to be directly applicable to damage caused by avatars, because the damage that an avatar can cause is more akin to that caused by a person rather than that caused by a thing. For example, a damage that a person could cause would be infringing someone's trademark by selling goods which are protected under trademark, rather than damage caused by an inanimate object, such as falling on top of someone's head. As you can see, it's more akin to that caused by a person. The Spanish civil law is tailored to ownership and possession of tangible property in this regard, so avatars are out of the question today. We might consider also harmonized product liability in this regard, but avatars are out of the scope of the definition of a product, and therefore this makes it unapplicable. However, one should consider as well the proposal for a directive for defective product civil liability regime, which might accommodate digital elements in this definition of a product, and in this regard, this just might change. Nevertheless, I argue that our fault-based regime is sufficient to cover the issue. First, we must consider harm. The main purpose of tort law is to indemnify victims for losses that they should not have to bear themselves directly or entirely. However, only compensable harm will be indemnified, so compensable harm is limited to a range of legally protected interests, and as of today, I argue that damage or harm will only be relevant if it is suffered by a person, legal or natural, in the real world. This is what the law is concerned with today. The extent of it, the harm I mean, will be proven by the plaintiff. So, using avatars does not inherently contest the existing range of compensable harm. However, regarding wrongdoing, while some of them depend on tangible or physical harm in the real world, such as killing or physical injuries, other types of wrongful actions or omissions can transcend these physical boundaries. For example, let's say an avatar infringes a real person's right, for example, the right of publicity. This has happened we've seen it, this has happened. For example, a real world's likeness is given to an avatar for commercial purposes. There is no doubt, I think, that said person would be entitled to compensation due to the digital avatar exploiting these traits for commercial purposes, not based on the misrepresentation leading to the consumer confusion or deception, but rather on the misappropriation of the commercial value of one's image. This happened in Hart versus EA in 2013. I can discuss this later. However, if we turn around and see what would happen if a real person misappropriates an avatar's likeness. To have a right of publicity, you have to be a legal person. Otherwise, you don't have that. So the question is, are there legally protected interests that can be asserted upon avatars? In fact, this misappropriation, I believe, of the commercial value of something unique and special is protected under our current laws. For example, by IP right protection. We have the ADA case that I mentioned before. So what would it take? The avatar would have to be original. The platform would have to be capable of providing a space in which the user can create something unique enough to be protected, and the platform not reserving the rights. I could give some other insights on this or examples, but I would refer to causation, providing that the user or avatar controller could be held liable for online misconduct. A factual and legal causal link between the avatar's action and the harm has to be proved by the plaintiff. So the plaintiff will have to produce this evidence. What I mean to say is that uncertainty and causation are not really new issues for us, and we have rules for this, unless we consider the approach of the proposal directive for a civil liability regime, which suggests adopting a presumption of causal link because it might be excessively costly for the person to prove it. Not because of using an avatar, and here's my point. This is not a consequence of using an avatar, but rather of using the Metaverse technologies. Lastly, fault has to be proven by the plaintiff, and in this regard, it is important to identify the duties of care that should be discharged and to prove that the conduct of the perpetrator of the damage did not discharge those duties. Moreover, these duties are determined by various factors, but bearing this in mind, running an avatar, unless AI equipped, can be measured according to duties of care designed for human conduct. So we don't have to invent fire again. Compensation will, of course, follow monetary form. So to finish and wrap up this presentation, this is the real world. This is not a detached, completely different. Our fault-based civil liability regime is mainly adequate and useful and sufficient to assess issues regarding avatars and their misconduct and harm caused by an avatar. Difficulties arising from this particular question do not follow the use of an avatar. It's not a consequence of using avatars, but rather using Metaverse technologies. So the user will be liable provided usual requisites are met. Thank you so much.
Thank you very much, Lorena. You have brought many questions that probably we can discuss later on, but I will just move to the following speaker, who is Giovanni SORRENTINO. He is PhD candidate at the University of Bologna, and currently he is visiting researcher at the University of Alicante. Giovanni, you have
the floor. Thank you very much, Julián. And I would like to stand up because I cannot see many of you from this part, so if you don't mind, I stand up. But, as Julián said, I'm Giovanni, I'm from Italy, but I'm spending my visiting research period here in Alicante, and I'm glad for this opportunity to the Metaverse chair and to all the professors in the International Law Department. But today I would like to open a reflection about a right that in the last years it's gaining really good importance. It is the right of a digital identity, especially in the Metaverse. And I would like to analyze the state of the art and then also to analyze some future challenge that in my opinion will be rise. My presentation will be divided in 3 parts. The first part I would like to analyze what identity and digital identity means. And in the second part, I would like to talk about identification and about the difference between identity and identification. And in the last part, I want to provide some insight about the state of the art and to just really fast insight about legal framework. So, this is the overview, but I would like to start my presentation with a question. The question is, who am I? Okay, you can reply, okay, I'm Giovanni, of course, and it's correct. I'm a PhD student, and it's correct as well. I am a 27 years old guy from Italy, and it's correct as well. So all of these answers are correct. But because the correct answer is actually one, is my identity. And my identity could be my name, could be my date of birth, could be my country of provenance, my job in some field like this. Or, for example, if I'm talking with my friends, it could be my nickname, for example. So, let's define what identity is. Identity is actually the collection of information, characteristics, and elements that allow a subject to be recognized by a society. Some feature, as I said, full name, gender, biometric also, and so on. When we put our identity in a virtual environment, we have the digital identity. And in this moment, the identity is actually less important than the digital identity because we live our life online, we can say. But there is a difference between identity and identification, in my opinion. Because identification is the process, is a system, is a proof to verify someone's identity. This is a really slight difference, but in the last year, some author is talking about this, and I really appreciate it. We have in this moment more or less three methods of identification. We can use to identify ourselves something that we know, like for example our username or our password. We can use something that we have, so for example our device connected with, where we receive a code, and connected with our username we can identify ourselves. Or the safest way, let's say, is something that we are, so our physical or behavioral characteristics. So for example, our biometric data, our face, our fingerprint, our voice. What is the point? All of these methods are good, they reach the goal, But they reach the goal in different ways, and not all of them has the same feature. For example, the first one, something that you know, it's easier to use because you just have to remember username and password, but it's less safe than, for example, something that you are using biometric data, because with biometric data we are sure that this person is actually the person that is trying to identify himself. So, what is happening now in the world? Here you can find some insight, some number. I like the number because they give to you the real image of what is happening. Now it's happening that 87% last year of people leave personal information exposed online. They do it also during while they are doing activities like using emails or bank account that are pretty sensitive activities. In US during 2023, for this reason, 1 on 3 of people have been victim of identity theft. This is translated in value in $45 billion in the same year in the same country, US. So this is just to understand what we are talking about, the importance of what we are talking about. But despite that, more than 100 countries and almost 3 billion people doesn't have a digital identity system. More than 110 countries are without a government-recognized system that provides a trustworthy digital identity. Some country is trying to provide some regulation, some law. We have a really good example now that is pretty new. That is the DIAZ in EU. Here you can find the 4 main regulations that in my opinion are the most innovative, but I don't want to focus on what we have. I want to focus on what we don't have. US is still missing a regulation actually. And if we go back and see these numbers, I have some question to raise up. But I cannot speak about all of this regulation because Julián will kill me. But I would like to leave only one insight to you. In the metaverse, in my opinion, the hardest and the most important challenge that we have is the interoperability. We cannot reach the interoperability without to have a real unique identity. And where are we? Well, I think we are at the beginning of the route, but the road is still very long on this. So thank you very much for your attention. I will like to thank you very much also to be here. Enjoy.
Thank you. Thank you very much, Giovanni. And now we will move to the last but not least presentation by A.Patricia LLAQUE. She is co-founder of the Metaverse for Good. She will present a paper authored by herself along with Domingo AMATO and Esther SÁNCHEZ on identity, experience, and extension in the metaverse.
Oh, thank you all. Maybe I should also stand up, but just for the opposite reason, just to let you all see me. No, I don't know. Well, I'm going to read the paper, just as you know, because this is a paper for a group of people. So, but as I can assure you, yeah, it will take less than 10 minutes. So, virtuality and neurotechnologies are increasingly pervasive in contemporary society as mediators of subjective experience through a dynamic interplay where biology, technology, and culture continuously feed back into each other. Within the wide range of neurotechnologies, the brain-computer interface, BCI, is of major importance from a social, legal, and ethical point of view, since its ability to establish a direct connection between our neural processes and artificial computation was described by experts in the field as qualitatively different. As such, the potential applications of BCI technologies promise to enhance the metaverse immersive experience. Advances in imaging, brain activity acquisition, and recording techniques, and the evolution of artificial intelligence systems that increasingly decode and analyze neural data provide VCIs with improvements in accessing, monitoring, and manipulating mental states for mental health, neurological rehab, cognitive enhancement, and device control purposes. The fact that many of these devices in their non-invasive form have entered the mass consumer market has increased concern about protecting privacy and the autonomy of our minds. Current privacy risks resulting from device-generated data could be leveraged with neural interfaces by providing even more ethically sensitive data for further sophisticated analysis of the psychographic profile of individuals based on mental characteristics and predictive behavioral modeling. The brain is a fundamental determinant of the meaning of being human, and therefore also plays a determining role in the shaping and development of our identity. The establishment of an ethical, legal, and governance framework that guarantees the protection of our privacy, our sense of self and identity is essential in an era where the biological body reconfigures its limits in symbiosis with hardware and software systems, and where representations of the identity through avatars give life to the metaverse. The complexity of these technologies, which are also constituents of the metaverse, requires an interdisciplinary approach, bringing together the legal, philosophical, neuroscientific, and technological perspectives. The aim is to develop a common conceptual framework guided by responsible ethics, providing precision in meaning and scope to ensure the protection of our mental sphere. As Joris Leithart points out in the European Convention of Human Rights Law Review, many of the central notions and concepts that are relevant to the protection of human rights, referring to personal identity, remain underdeveloped and ill-defined in the jurisprudence of the European Court of Human Rights. Likewise, he pointed out that this court develops and applies on a case-by-case basis a right to personal identity and personality, referring to the importance of preserving mental stability, although without defining these notions or elucidating a clear conception of what identity and personality require and what they consist of. To address the legitimate concerns about the sustainability of current human rights expressed by scholars such as Marcello Jenka and Roberto Adorno, there is a strong need to bring greater clarity and precision to the existing legal concepts relevant to the protection of the mind and how these concepts should relate to each other. The ethical challenges posed by BCIs, among other neurotechnologies, compel us to face a fundamental question: whether it is legitimate to access or interfere with a person's neural activity, and under which circumstances. The motivation is threefold. First, scientists explain neural activity as the critical substrate of personal identity, and therefore also as the critical substrate of moral and legal responsibility. It follows logically that the decoding and manipulation of neural activity by means of neurotechnology may have an unprecedented impact on the personal identity and may provide them with a kind of blurring effect or even produce a real threat in terms of an uncertainty in determining moral and legal responsibility. In this paper, we are focusing on the right to psychological continuity related to the right to personal identity, the right to self-determination, and the right to personal integrity. As Jenka and Adorno claim, the right to psychological continuity can be seen as a special neurofocused case of the right to identity. From different approaches, philosophical, neuroscientific, among others, we have addressed the foundation of personal identity, with a special section dedicated to autobiographical memory and sociability, where we analyzed, based on neurophilosophy on sociability, some of the elements that constitute the basis of this relationship. The aim of this analysis is to review the influence that this link exerts on the construction of identity. Tackling the complexity of defining identity exposes us to the limits of language and the multiplicity of possibilities. Therefore, we propose a conceptual methodological solution based on categories that must take into account a way of being and being in the world that is permeable relationship of values and disvalues between the individual and his environment, as well as self-knowledge and recognition. In addition, we also looked at the need to explore the environment around us in its less tangible forms. Despite living in digital societies, we often avoid taking responsibility for this digital realm. By considering the extension of human existence to a plane that transcends the physical, we intervene in an alternative realm. Virtuality allows us to live a myriad of experiences from a first-person perspective, although always subject to the degree to which experience is perceived as real. Superrealism leads us to question the mechanisms and dynamics that potentially influence our identity and its virtual representation, an avatar. But also our interaction with the virtual characters that accompany us and the construction of worlds in which to reflect ourselves. The consequence of human actions in the metaverse may seem to have no non-tangible repercussions, but it is essential to reflect on them because of the impact they have on our identity. These actions provide a revealing mirror into our individual and collective identity. Therefore, the analysis and study of virtual worlds can offer a valuable perspective for analyzing various aspects of human behavior, one that also requires the observance of norms and ethical guidelines, as well as the flexibility of behavior to adapt to the changing dynamics of each context. One of the Metaverse for Good key objectives is the development of a common conceptual framework based on the principles of responsible ethics and in the light of human rights. This involves looking at human agency in virtuality and investigating the real impact of the neurotechnological devices that shape our presence in the immersive world. In the light of all the above mentioned, we draw some preliminary conclusions. On one side, the metaverse and the conceptualization of the avatar must be analyzed from perspectives that transcend their ludic character. This framework grants agency, allowing socialization, experimentation with new value systems and personalities, and decision-making without the repercussions inherent to the physical world. This situation opens up a range of possibilities. We can be whoever we want to be. An avatar not only allows us to design and mold our identity as we wish, but also facilitates the exploration of any behavior or value, allowing experimentation and decision-making that we would otherwise never consider, as well as execution of unthinkable actions. In this way, we reflect ourselves without restrictions in this permissive world. The underlying question is the relationship between the absence of punitive consequences and human behavior in an environment where normative and social constraints are non-existent. To what extent would human behavior be freed from its inhibitions? This question leads us to consider the very nature of social and legal order and its ability to shape and contain human actions in a balance that allows harmonious coexistence. On the other hand, advances in the world of neurotechnologies require an interdisciplinary debate to ensure the protection of our mental sphere. It is still being elucidated whether the legal doctrine and human rights in force can ensure such a defense. In the case of the identity, characterized by its continuous permeability, there is already plenty of research that highlights the modification of underlying neural and mental states through brain modulation, invasive and non-invasive. The key concern is that emerging neurotechnology may have the capacity to modify psychological traits essential for the continuity of a person, or in other words, that neurotechnology may be able to induce profound changes in authenticity by altering character and personality in such a way that it makes alterations to our identity and turns us into another person. We propose, therefore, to continue this research with the following broad objectives. A compilation, not yet. Following broad objectives. A compilation analysis of the existing literature that reports such alterations, as well as to deepen in that which argues that the current brain modulation is not yet capable of inducing those effects in such a radical and comprehensive way, and also delve more deeply into brain technology and their increasing capability to track and influence our mental states. Both actions will allow us to elucidate more precisely which theoretical approach or approaches to identify is the one of concern in this neurotech-driven world. Thank you all.
Thank you. Thank you, Patricia, for this different approach, not legal but very interesting and related to our topic today. And now we will move to the comments of the discussants. We are honored to have with us two amazing discussants on this panel. First, Lisa KÄDE. She is an attorney at JBB, based in London. She's manager of the Robotics and Artificial Intelligence Law Society, and she's a lawyer specialized in artificial intelligence and copyright. Lisa, you have the floor.
Thank you very much, and thank you also for these very great presentations and insights into these very, very diverse aspects of avatars. So I'm going to do this a bit differently than the previous panel, so I'm going to give a short summary of what we just heard, because we are going to see that all of your presentations or papers really tie together like a jigsaw puzzle almost, which I find is really amazing. And then I'm going to pose some questions to each of you. So in one of your papers, I guess I read the definition or the origin of the word of the avatar, which I believe was the earthly manifestation of a deity, which of course in this case is ourselves, probably. At least in the case of where we have the entire control over the avatar. What I find really interesting about all of your papers is that you are discussing the matter of identity from very different perspectives. So we have heard about outer aspects of identity, like for identification, authentication purposes. We have heard about inner aspects of identity, especially from a very philosophical and almost sociological perspective with regards to what makes up our identity as a personhood, as memories that tie into our past and that are now probably being extended into the metaverse. We also heard about the question whether we have to talk about a plurality of metaverses or whether we can tie them all together into one metaverse. We heard about the right to publicity, especially with regards to commercial exploitation of an image when we are building up an avatar. So we heard about several court cases which are addressing the issue of exploiting, for example, the likelihood or the likeness of a public figure, which is now then moving around in the metaverse maybe in the future. Also, of course, there are a lot of issues centering around the question of liability, be it criminal or civil liability, and the question of also can avatars maybe be able to conclude contracts. not just contracts, but also how they can cause harm to actual physical human beings or objects. So there is one parallel or one thought that came up to me. I don't know who of you still remembers the video game The Sims. It's been a while, but I guess if we now tie into the idea of smart avatars, which also came up in some of your papers, the idea that companies are actually putting simulations or avatars into a virtual world to be able to offer services or to sell products in the real world. Should these avatars be regarded as an agent or as a representative of that company? And if these companies are buying, for example, the avatar by a commercial provider of this metaverse, and the avatar is not doing what the company expects them to do, who is liable? Are they still in control of that avatar, or should the provider of the avatar be liable? Which ties into AI regulation as well, because with smart avatars, we're obviously moving towards AI regulation, and as we heard in the beginning, maybe we should always take into account AI regulation in the context of the metaverse as well. Because we heard that there are transparency obligations in the AI Act, which make it necessary to identify an avatar which is controlled by an AI system, in contrast to an avatar that is controlled by an actual human person. Which takes me to one notion that wasn't addressed so far, but I think which might tie in with what we just heard, is the high-level expert group on AI, which in the years of 2018 and 2019 came up with some guiding principles how we want to regulate AI. So these were not concrete regulatory propositions, but merely ethical considerations to be taken into account, such as human oversight, data governance and privacy, technical robustness and security, diversity, non-discrimination and fairness, societal well-being and transparency. And I believe if we look at avatars and the regulation of avatars, and also the concept of building up a new metaverse which ties in together maybe different metaverses that are already out there, we have to think about whether this would be some kind of digital state or new state, and whether we have to come up with a new social contract of sorts to come up with rules for avatars to be adhering to. And maybe these guiding principles, which are guiding the AI Act as well, could come in handy there to come up with a regulation or some kind of terms of use for this new state of the metaverse. So all this considered, I still want to address some individual questions to you. So Vera, Lúcia, you really provided a really great analysis of the legal personhood, and one aspect that really stood out to me was the comparison of the EU and US right to publicity. So I would like to ask you, what do you think are shortcomings with regards to avatars in the current framework of the right to publicity, especially smart avatars, and how would we have to adapt the framework if the avatars were granted some kind of legal personhood?
Should I answer now?
Yeah, you can answer.
Should I answer now? Yes. Well, under the current legal framework, in the US, they seem to have the question quite solved with the right of publicity, and it all depends on whether the court understands that there is actually a strong similarity between the avatar, or it doesn't have to be an avatar, might be any other figure. We are talking about avatars, but this might happen with some kind of replica of a human that is not an avatar. In Europe, the question is a little bit more interesting or complicated, depending on the perspective, because such a right never was really accepted. Eventually, we don't need it. I will assume, and by the way, I'm not familiar with any case discussed in Europe regarding avatars. We do have questions in which the image of a person was used for a different purpose. And we have used our, for instance, under European Convention of Human Rights, you have used Article 8 and the right to private life, because as you know, this is Article 8 stretches quite a lot, and it can include many things. I would assume that eventually the right to image, we have a similar case in Portugal, not with avatars, of course, but in which the right to image was used. And the other question is if you can use the image of a deceased person, and again, it's a little bit different regarding jurisdictions, but we will use these rights. But this is under the current legal framework, and in a sense, I do agree with the idea. I forgot your name. Lorena, I'm sorry, yes, age. I fully agree with you. I think under the current legal framework, we don't need to create anything new, because all these issues, either with avatars or metaverse in itself, we can solve with the existing laws. Basically, it's a kind of legal transplant. We are using laws created for physical realities to digital realities. There might be some adjustments, of course. You need some adjustments, but you don't need to create new law. Now, with these AI-based avatars, in which, and if you have a kind of AI in which humans are not really necessary, we will be like bystanders, but not really active, this will be a game changer, not only for the metaverse, but for the AI itself. And eventually, we will need to create new laws. As for the right of publicity, I think the only change is that instead of having a person, either a human or a legal person, being accountable for the right of publicity, you will have AI, which, needless to say, will create so many issues. But there you have the AI liability directive and the new consumer liability directive. Thank you.
Thank you so much. And yeah, moving on to Lorena, María, you gave a really strong analysis of the legal framework regarding non-contractual liability of acting avatars. One of the questions would be, what should be the focus of legal regulation? Do you think the existing regulation is enough, or what should we focus on? And also tying in together with that, who should rule actually over the avatars? So if we talk about one metaverse, are there still terms of use? Will there be some kind of a virtual state, or where are we moving in that perspective?
Thank you so much for your question. I believe the landscape is, of course, very complex because we have this barrier, which are the terms of services. And it stands for autonomy of the will, which, I mean, it's really, these are not really, as stated here, not really new issues. I believe that there is really not need for further adaptation. Not much further adaptation. Maybe we could discuss about, regarding civil liability, about the reversing the causation link, but just as a matter of proof, because we don't have new questions regarding, for example, alternate causes obscuring the causal link. So if the question is, should we manage or should we keep regulating to encompass avatars, I believe that wouldn't be the best idea of all. I believe our current regulation, this is, I think, true for Spanish law as well as most European countries. So I think we can manage with what we have right now.
Okay, thank you very much. And Giovanni, you provided a very broad analysis of international digital identification frameworks, which I found really intriguing, and also of different national or EU approaches. So how does it tie in, for example, with something I would like to call somewhat of a keychain or a closet of avatars? So I feel like whenever we are moving around in the digital realm, we make use of the opportunity to give ourselves a different identity or highlight some part of our internal identity, which we then create by designing the avatar specifically to what we want to highlight about ourselves, which might not come out in the real world as much. So we might be willing to have different sets of avatars for different purposes in the metaverse, which could tie together like a credit card, for example. I have a wallet full of different credit cards, which all tie to one person. Is that something that could happen for avatars as well? And also, how can the need to identify an individual be balanced with a desire for anonymity? Or should we approach the metaverse or a new metaverse to be created from a different perspective with less anonymity and more accountability?
Thank you very much. You touched a really good and important point. First of all, I will start with the avatar topic. That's true that avatar is part of our digital identity now. What are doing the lawmakers for this? Actually nothing, in my opinion. Well, some reflection is starting in this moment, in the last years. I think it's not enough, because I remember a speech that Martin had some months ago here in Alicante. We were discussing about the relation between identity and avatar. And I told him that, in my opinion, the definition of identity cannot stand alone, of digital identity, cannot stand alone without a definition of avatar. So, what is the avatar? It's part of our digital identity in this moment, because we interact through the metaverse, but also through the, let's say, virtual worlds, through the avatar. So yeah, I think it is a starting point for the lawmakers to define what an avatar is, and then he can start to put this inside the definition of identity, and specifically digital identity. Also, you touched a point that I just talked really fastly in my speech, but it's actually the base of my speech. That is the interoperability of the identity. So my paper, the title of my paper is a unique towards a unique digital identity. In this moment, do we have a unique digital identity? No. This is my answer in this moment. We don't even have a common definition of digital identity in my opinion now. That is that we can say, okay, this is a good definition. This is a good law about it. And arriving at the last question. About the balance between the identification, to like how to be sure that that person is exactly that person. In this moment, I think the answer is not legal. I think in this moment has to be technical. Once that we have some technical tool in informatic that can solve this problem, then we can start to think about a good law about it. In this moment, some technical solution is there in the corner waiting. Like, for example, blockchain has really good application on that, but it's still far away.
Thank you so much. And maybe the brain-computer interface might be a way to technically address the issue of identity. So, Patricia, I found it really interesting that you highlighted in your paper, together with the other authors, the internal aspects of identity. So what makes up a person, and what are the cognitive topics that we have to talk about. And you also touched upon 4 new human rights you are proposing. Those were the cognitive freedom, mental privacy, mental integrity, and psychological continuity. So my question to you would be, on the one hand, how avatars affect our self-perception, also our sense of being, and on the other hand, what would be your wish towards a regulator of the metaverse, whoever that may be, if you could choose one of the suggested new human rights, and why?
Yeah. Well, first of all, I would like to thank, Aurelio and Julián, because they really like to work in an interdisciplinary way that, for me, is the key for a good regulation. I'm a bioethics and neuroethics director in another association here in Madrid. And I had the opportunity to interview not only Rafael Yuste, but also Roberto Andorno, Marcello Yenka. And I've already worked with many scholars that come from the legal perspective. And unfortunately, I must admit that I feel absolutely vulnerable. Yeah. Maybe because I come from the technological path, from the scientific path, so I know what technologies are. Yeah. And even for us, sometimes it's also difficult to understand this kind of explainability. Not we have talked or was mentioned the way interpretability. It's another thing. No? In that sense, for me, I'm still waiting how the AI Act is going to be. Or it's going to get its path to get in an operational way. Yeah. So design, ethics by design from the first place, I would think that it is a good starting point. Yeah. Talking about Avatar and its impact on our identity. The identity, unfortunately, it is a paper of 36 or 33 pages. And it is a sum up of what we've been discussing, and as I already mentioned, we have already some forwarded papers regarding what is identity, all the alternatives, because we can speak not only from memories that you have already mentioned. Of course, I did it so, but also beliefs, intentions, desires. That's maybe an extension of the John Locke numerical approach for identity. We are talking as well from a biological point of view of extension, that we are referring, of course, to the physical sphere. And one that I really like is the numerical conception of, the narrative. Why I'm really keen of that option? Because I do believe that identity is permeable to each and every experience of us. Yeah, it doesn't matter if in this physical space or as an avatar, a meta-human or whatever. No, we are trying to. Each experience is molding our identity. Yeah, we already know that neurotechnologies, that this is neurotechnology. We are not waiting, to be implanted with a chip, an invasive implant. No, this is already neurotechnology. We already know impacts on cognitive, not only attention, but also what it is named, I don't like the name, but what we all know, but emotional intelligence, because it is focus, concentration. It's also very important to regulate our self-emotions. Of course, our GPS, that we all have a GPS, is already, unfortunately, losing his power. And I do believe that there are already sufficient historical, and to dig in and see how our identity is also changing, through these experiences. So in that way, avatars, right now for me, I am working in something that is called suprarealism. And maybe it's the difference between psychological and physical realism, is that although we know that something is not real, we do feel that it is real. So when suprarealism, because of sensors, because of BCIs, other technologies, right now we have already in the market facial, body, eye tracking, already a lot of sensors. When all this would hack our senses, how is identity going, to find itself? So I do, and absolutely, I'm firmly convinced that right now it's a very interesting starting point from getting, deeper in the concept of what is identity, because it has a lot of, as I told you, a lot of features that are already, his influence in changing, and not only our, but of course, our next generations, because as I told, at the beginning of my paper, there's a continuous interaction between biology, technology, and culture. So don't forget that, please.
Thank you very much.
Thank you, Lisa. And thank you to our speakers. And now it's turn to Martin Evers. Martin is Associate Professor of IT Law at the University of Tartu, Estonia, and President of the Robotics and Artificial Intelligence Law Society, among many other positions. Martin, please, you have the floor.
Yeah, thank you so much. Since the session is actually scheduled until now, so the question is a little bit how much time we have, more or less, to discuss.
I
15 minutes,
10 minutes,
maybe?
because we have started a little bit later.
Okay. So my idea actually was to pose a lot of questions. And I see also that these papers are strongly connected to each other. How I see it, so first of all, it's really fascinating to see that all of you explored the topic of digital identity from different perspectives. And how I see it is that, Giovanni, you basically focused on identification. Yes, you made the point that identification is not the same as digital identity, but your paper basically focused on identification. Whereas you, Patricia, actually, you make the point we can be in the virtual realm whoever we want to be. And therefore, I will follow then with you, as a second. And third, Lorena, you made the point that through avatars, users can cause a lot of damages. And I think the most far-reaching paper then is Vera's paper, where she explores the possibilities of conferring maybe some kind of legal personhood to AI avatars. So the idea of my intervention is basically to pose a lot of questions. You do not have to answer to them. And so the idea would be really that I pose these questions to you in this order, and then the chair can decide who has how much time then to respond to which question. In any case, maybe it's an incentive to take it into account then at least in finalizing your paper. So Giovanni, you explored identification. And my first question would be, why is that really a problem? Because if someone is a user and then enters the metaverse, usually that is done via a platform. And the platform provider, in cases where it really matters, will make sure that this person is identifiable. So why do you really make this point? And then, when we look into the different methods of how to identify someone, what do you think is then part of this process? So is it then the natural entity, or the legal entity, or the legal roles even? So what kind of power of attorney, for example, a person has, or even more far-reaching credentials such like diploma, access rights, and so on. And then the next question would be how to prove identity. So you refer basically to the existing digital ID frameworks, but in the metaverse, there's of course also then other possibilities how to identify someone in a very unique way. For example, body-based identity. So all these traces and inferences that can be made on a person then could be also used for identification purposes. Or you could maybe make the case, no, it should not be used, because that would be too far-reaching and somehow violating privacy rights. Then the other question is, should there maybe even like an obligation to reveal your identity? And there's of course pros and cons, and very far-reaching would be even if there would be an obligation that the avatar looks like the user. Last but not least, you deal with the question how to harmonize identification across platforms. And there, as some little remarks of me, maybe you could look also into portability rights, because EU law foresees portability rights. And if one avatar that is created under a certain environment can be transformed, transferred to another platform, then maybe all these questions that you pose regarding the identification across platforms could make it easier. So we have Article 20 of the GDPR, and also the Digital Markets Act actually foresees a right of portability vis-à-vis these gatekeepers. Patricia, when you spoke like about the other aspects of identity, you also mentioned the European Court of Human Rights. Indeed, that is super interesting, and in my own paper, which is still not finished, although I presented it, I think, a year ago, I also deal with the case law. And I think it's very interesting to look into this case law. Of course, it's not about digital identity, but there is a case, or lots of cases where the European Court of Human Rights explored this right to identity. The most interesting part, actually, of your talk, I think, was how also the mental state is manipulated, and that somehow connects it, I think, to Lorena's paper when she talks about harms, because many harms that can happen in the physical world do not happen in the same way. So for us lawyers, I understand that you are not a lawyer, it matters what kind of harms actually there are. So can it be measured? Is, for example, a user really suffering pain, and can that be measured in case the user's avatar gets raped, for example? Then Lorena, I have most questions to you, because your paper was really very interesting and I enjoyed it very much. Well, one aspect maybe you could also take into account is that what we can do with the avatar pretty much depends also on the digital environment, on the architecture of the metaverse. And there have been already instances where platform providers or metaverse providers or virtual reality providers took action when they saw that something happened on the platform in order to prevent this from happening. So, I mean, basically it is the platform provider who makes it possible that I can fly, that I can slap someone in the face, or that I can rape another avatar. So that maybe is something that is interesting. And then you also talk about the terms of services. And then the question is, maybe here also users can be protected in that the terms of services apply, because they are usually much more strict than the law. And then, of course, there should be maybe some kind of control also. So are they subject also to review of terms of conditions? Then you talk about liability of platforms. And there, I think we will have also tomorrow a session on content moderation. But maybe that could also rise to civil law liability if the platform provider does not take enough actions in order to prevent harm from happening. Last but not least, the types of harm. Yeah, I totally agree. It's a very interesting question to see how actually what happens in the physical world and all these legal concepts that we have developed can be translated to the digital realm. I think you really made the point that many of the harms can be somehow translated. Of course, a rape is not a rape, but then it's some kind of immaterial damage that at least this person has suffered. However, then it needs to be determined when we have not a physical damage, what kind of damages are subject then to these claims. Last but not least, Vera, you made especially 2 points. One is you talked about property and IP rights on avatars, and you came up with the idea that there should be somehow a shared ownership between developers and players. And I just wonder how that could happen. So, for example, there are platforms that allow us also to create our own avatar that looks like us, and I pay money, of course, for that. And then for some reason I do not want to continue with this provider. So how should this then work? So I have created my own avatar. It has been created in the way I look like, but on the other hand, the company that created my avatar spent a lot of money into AI training in order to create this avatar. And last but not least, then you made the point for a legal personhood. I'm a little bit skeptical, and I do not see, first of all, the necessity of it, because even if we have an AI autonomously acting avatar, there is a company behind it. There is a user behind it. This user can be also identified because somehow you have to have access to the platform. So I do not see so much the case for it. And then I would say also it creates a lot of problems when we recognize some form of legal personhood. First of all, how can you identify the avatar if the avatar gets copied, deleted, and so on? And then also how to equip the avatar with assets. So who should actually pay into these assets is then a question. And last but not least, of course, if we recognized such like legal personhood of an avatar, it could also lead to the effect that then companies could just say, well, we are not responsible, it's the avatar that is here responsible. So wouldn't that maybe have a lot of negative consequences? One last sentence. The OECD actually in its principles they adopted on AI ethics, they made the point that there should not be, that there must not be any form of legal personhood to AI. And 193 states worldwide actually signed this and are obviously of this opinion that there is not a case for legal personhood. So these are all my questions, and wow. I hope at least for some answers. Thank you.
Thank you. Thank you very much for your insights. I think it's impossible to answer all these questions, but for sure they will be very helpful for our speakers to the final version of the papers. And I will give you, all of you, 1 minute just to pick one of these questions or to give your final answer. We may follow the same order. Please, Giovanni first.
Thank you, Martin. You provided tons of food for thoughts, but I think they are hungry also for normal food, let's say. But anyway, I will try to touch some point. About identification is totally different than identity, as you said. I treated identification more because of ADAS 2, and now it's something hot. But for example, my thesis is more focused on identity from a substantial point of view. Talking about the different methods of identification, you talked about a unique identity framework, and I totally agree with you. Of course, biometric identification is the easiest one to give to the users, is the safest one, but is also the most impactful, like the most dangerous, let's say, because if someone stole my biometric data, I don't have anything else. Talking about the obligation of... Oh, yeah.
You have to be one. I mean, sorry.
Yeah.
We can follow the discussion during the lunch, but I have to stick to the schedule, and we are already running behind. So, Patricia, 1 minute.
Yeah. Well, we already have, many examples from Meta and so on. This space, that was created because, women already, claimed that they were not only, or maybe not even raped, but they feel touch, because of these sensors. So we already have a lot of unfortunate examples. The main thing, about measuring is there's a lot of subjective experiences, of course. We're talking about pain. What's more subjective than pain? No? And just another maybe also challenge, correlation, causality. Yeah, but of course I would improve this paper with all I know about it. Danke sehr.
Thank you, Lorena.
Right, so first of all, thank you so much for all of your comments and all of your insights. They are very useful and will be considered for the final product of this research, of course. Can users be protected when applying terms of service? Yes, they can. And this is when Bragg versus Linden comes in handy. This happened in 2007. I believe this is the first metaverse-related case to be judged by a court of law in the United States. And in this case, the user exploited a bug which allowed him to purchase land below market value, virtual land. And in this case, there was this clause which was considered to be unenforceable because it was unconscionable. It was abusive for the user. The court of law considered this abusiveness of the clause because it provided no alternative resolution mechanism for him, and then protected his right to access to justice. So yes, we can be protected today for the narrow or restrictive application of terms of services. Although in this particular case, I love it because it doesn't answer a very good and a question that I am passionate about, which is what happens to legal property in virtual worlds. I cannot address this here, so thank you so much for your question, and thank you for having me here.
Well, and finally, Vera, you have the floor. 1 minute.
Julián asking a woman to talk 1 minute.
I know.
It's impossible. Well, so I will focus, well, first of all, thank you so much, Martin. I will focus on the issue of legal personality of avatars. Well, and let's not be mistaken, this is not about avatars, this is about AI, only because I only sustain regarding AI-based avatars. So the question is, should AI have legal personality? For the moment being, I do not disagree with you. No. Even though last week, there are people sustaining it. Last week in Oslo, a colleague of mine was sustaining that, and his point is the best way to address liability issues. I disagree with that. I think that granting legal personality in the current moment will open more problems than the one it solves. However, if and when strong AI comes, and we don't know what that will be, probably I will not be alive, probably you will not be alive, unfortunately, but someone in this room, because we have very young people, will be, that might be a game changer. And I'm not sure if you have this kind of AI that it will be very difficult, probably, I'm saying probably because I'm not there to see, I cannot even say what will be strong AI. We will not be able to grasp the causal connection between the AI manufacturer and the AI itself. I don't know if that AI comes. And if that is the case, I think we might not have other option. That being said, the kind of legal issues it will open, It will be so interesting. I'm just upset I will be dead by then. Thank you so much.
Thank you. Thank you very much.